Join us live every Tuesday from 4 p.m. to 5 p.m. Eastern Time on GluFM for Minding Your Business with me, Attorney Rishma Eckert, to discuss the law and your business. Email us with your questions at info@mybshow.com. And remember, success comes from minding your business. Welcome to another episode of Minding Your Business. I am your host, Rishma Eckert. I am a business law attorney with Eckert Law, PLLC. Today, we have a very, very special show where we're talking all about bankruptcy law because you, our listeners, have asked, and we are here to provide and give you resources. So we've asked a very special guest to join us today to talk about bankruptcy law. But before we get into that, remember our features for our show. We have the MYB Small Business Spotlight, where every month we like to spotlight businesses who have been affected by the pandemic so that you can get a exposure to our different markets. And as Lisa said, we're in New York, Kentucky, Florida, parts of Asia, parts of Africa, Jamaica, Canada, and the UK. So if you would like to be considered for our MYB Small Business Spotlight, please go ahead and email us at info@mybshow.com. Also, we do a feature called Ask MYB, where if you want us to explain a particular topic to you, or you want us to expand on what we've already explained in the show, please go ahead and let us know, because we have turned actual questions into whole shows. So go ahead and email us at info@mybshow.com. This month is Caribbean American Heritage Month. So I would like to give a big shout out to all our Caribbean American business owners in all our markets. Keep doing what you're doing. Good job, and keep representing our culture. Before we get into our special guest today, my quote of the week comes from Gandhi, and he says, "Freedom is not worth having if it does not include the freedom to make mistakes." Now, the reason I wanted to talk about that today is because we're talking about bankruptcy law. And a lot of people think that because you fall on hard times, or you may have made some irresponsible financial decisions, that's it. You're a slave to the world, and you no longer have any freedom. But you also have to give yourself the ability to make mistakes and pick yourself up afterwards. So don't be too harsh on yourself, especially business owners. It's really the trials and tribulations of business ownership. You go through it. You get the resources. That's why we're here as a program as well, to be able to provide you with resources and knowledge, and you pick yourself up and you keep on going. So it's not the end of the world if you make mistakes and you find yourself in a bind. So with that said, I would love to introduce our very, very special guest. I'm so glad she's on the show today, Ms. Theda Page, and she is a bankruptcy attorney with the Page Law Firm. And I will have her introduce herself to our listeners. Hi, Theda. How are you?
Hi, Rishma. Thanks for having me. Sometimes it's not even a mistake. It's just the circumstances we're in. I mean, when we think about COVID-19, who could have predicted that? And
Correct.
So, people made business decisions based on what they thought life was going to be like. And since unless you're probably older than 100, you probably have not experienced a pandemic like this. So
that's exactly right. It's a combination of a lot of things. And we've talked in our previous shows too about being able to just navigate, again, the entrepreneurship road is not an easy one. Yeah. So we have to be able to know how to navigate that. And you're right, it's natural disasters, mistakes, whatever the case may be, but it's not a failure. It's not the end of the world. It's just an opportunity to do something better.
Yeah.
So
I like to say that our office is the no shame, no judgment zone. So
I love that.
My name is Theda Page. I'm with the Page Law Firm in Frisco, Texas. And Frisco is a suburb just north of Dallas. And we opened our doors. I'm the founder. We opened our doors 19 years ago. And even before that, when I got out of law school, way back a long time ago, my first job out of law school was working for a law firm, worked for the partner who did bankruptcy. And I fell in love with bankruptcy back in the 80s. And I used to joke and say that you couldn't be chic and fashionable if you hadn't filed a bankruptcy back in the 80s. That's when the oil and gas industry that was so prevalent in Texas went bust. And so it impacted not just that industry, but all the industries that touch that. And that's kind of what we see with COVID. It may not necessarily be something that you did in your business, but you have a business that was impacted because of another business you did business with. So it's kind of a trickle-down effect. I primarily represent individuals. I do represent some small businesses who decide to close their doors, and they're trying to figure out, what do I do? Do I file a bankruptcy, or do I just walk away? And we can talk about that in more detail if you like. If you have some questions for me, just let me know.
I do. So the format of the show, just briefly, is that I would like to ask you very targeted questions with the different types of bankruptcies, some sort of eligibility, what people should be looking for, what type of information they need to provide to an attorney like you if they're even considering it. And part of our show is opening up the show for live questions. So because we've been requested to talk about bankruptcy, the listeners out there, if this is your opportunity to ask questions, and you have a bankruptcy attorney to ask them to, because they usually ask me and I have no idea because I don't practice that type of law. So we do have a portion where we would open up for questions, or if there's a question that comes in, Lisa will interrupt and ask as we go along. And at the very end, I would like for you to give some general recommendations or suggestions to our listeners, and then we wrap up the show. So that's generally the structure. So let's just jump into it. I have a lot of questions from a business law standpoint, but just for general knowledge, I hear people talk about Chapter 7 and Chapter 13. What are the differences with those two?
Okay. So a Chapter 7 is available for individuals, and it's available for businesses. Some people call that straight bankruptcy or liquidation. And when you think of liquidation, you kind of think about the fire sale, the rug stores. We're liquidating, we're closing our doors.
Yep.
So it's kind of scary when you say, Chapter 7, it's liquidation, because people think, are they going to come to my house? Is it going to be like the rug store? They're going to put all my belongings on the front lawn and sell them? Nah, not at all. But it is because most of us have whatever assets that we own. They're assets that can be protected. So there is no liquidation sale. But that is typically what happens in a Chapter 7. It's over in about 90 to 100 days. And in a Chapter 13, that's a repayment plan. So you might be in a Chapter 13 for 3 years or 5 years. That is available for individuals. It is not available for businesses. But if you're a small business owner and you've personally guaranteed a lot of debts for your business, you can file a Chapter 13 and continue to operate your business. You are in bankruptcy. Your business is not in bankruptcy. There's a repayment plan. There's a formula that determines what you need to repay your creditors. So that's a little bit longer than a Chapter 7. Most people are thinking about a Chapter 13 if maybe they have some mortgage problems. Their home has been posted for foreclosure. A way to stop a foreclosure is to file a bankruptcy. Chapter 13 allows you some time to repay your back payments that you owe on your mortgage. Maybe it's an IRS garnishment. Maybe it's a student loan garnishment, something you're trying to stop. Chapter 13 is a great strategy to help you restructure that kind of debt, give you some breathing room, get yourself on a different kind of payment plan, and move forward. Bankruptcy is all about a fresh start.
I love that approach to it. As an individual, how do you choose? Do you choose if you're going to do 7 or 13, or is that something that they would sit and do a consultation and you would recommend?
Yeah, so sometimes individuals have some idea in mind I want to do, and sometimes they'll even say, I want to do a Chapter 11. Individuals can do a Chapter 11, but generally that's more for JCPenney, American Airlines, General Motors. Those are, Chapter 11 is more designed for individuals and entities with significant amount of debt. But you can put your small business into a Chapter 11 to restructure. The best thing to do when you're thinking, do I need to file a bankruptcy? I'm not really sure, is to reach out to a bankruptcy lawyer and sit down and talk to them so they can determine what's really the best course of action for you. My favorite is a Chapter 7, but that's not for everybody.
Right. What sort of, what would disqualify you from going for a Chapter 7, for example?
So we still call it the new law, but actually that law is about 16 years old. But Congress changed the bankruptcy laws. And so now there is a test that you take. It's something your lawyer prepares. So it's not like you go to the testing center and take a test and see, are you good with money or not? But it's based on your income and your household size. However, you may also qualify without taking that test if your debts are primarily business debts, not consumer debt. So if you owe the IRS a lot of money, but you've got good income, you just need some help with your taxes, Chapter 7 might be a good option for you. But the best thing to do is talk to a bankruptcy lawyer.
Right.
Weigh the pros and cons.
Absolutely. And one of the questions I get asked all the time is that if you decide to do a Chapter 7 bankruptcy, is it that you don't have to pay anything at all? This is not the one we're restructuring. I get asked all the time, does it mean that I have to pay anything if I decide to file for bankruptcy?
Okay, so I get that question too. When you think about what I'm not repaying in a Chapter 7, it's more like credit cards, medical bills, payday loans, that kind of thing. If you've got a house and you want to keep your house, you've got to pay your mortgage. If you've got a car, you want to keep your car, you've got to pay your car payment. Some taxes are eligible for discharge in bankruptcy. So my record, and I'm pretty proud of my record, for one couple, we discharged $120,000 that they owed to the IRS. So if people think, I can't get rid of taxes in bankruptcy, you need to talk to a bankruptcy lawyer.
Discharge for our listeners mean they don't have to pay it at all.
That's right.
They don't have to pay. Wow, it almost sounds like a magician, like a miracle that you just had it just disappear. I see that we have a question from a listener. Lisa?
Yeah. When should a person file Chapter 11?
If they need to restructure their debt and they have more debt than the debt limits of Chapter 13. And the debt limits in a Chapter 13 is $1.3 million of secured. So think about houses. And maybe if the IRS has a lien on your house, you may not have $1 million mortgage, but if you've got some IRS debt and they've put a lien on your house, you might be exceeding $1.3 million. And for unsecured debts, it's about $375,000. Wow. So I'm going off the top of my head. Obviously, when I'm looking at a particular case, I have my bankruptcy code out and I'm checking my numbers. So
yeah, same here.
That's a ballpark number.
To double down on that question, to double down on that answer, a lot of the other questions I get regarding bankruptcy is, for example, how far do they look for assets? Like how far back, I mean. So someone will say, for example, hey, I have a joint account with my parents and I have, but I just have it there to help my parents out, but it's not my money. Or I have this thing in a safety deposit box. They're looking specifically for things that can be considered assets for the purposes of if they qualify or not. Mm-hmm. So I guess my question is, what sort of things do, I guess the trustee would be looking at in terms of assets, and how far back do they look? Your whole life, a year or two? How does that work?
So bankruptcy is a snapshot in time. It's what assets do you own on the day that your bankruptcy case is filed. So having said that, if you have $10,000 under the mattress and you say, well, I'm about to file bankruptcy, so I'm going to gift this $10,000 to my brother, and my brother's going to give it back to me in a couple of weeks. And nope, that will not work. When you file a bankruptcy, there's lots of paperwork involved. One of those documents is called a Statement of Financial Affairs. Now, I call that document, bankruptcy lingo, we call it the SOFA, the Statement of Financial Affairs. I call that document the Janet Jackson, what have you done for me lately document, because the kinds of questions that they're asking is what's been going on lately. And lately is, I just gifted my brother $10,000 that he's going to give back to me. Oh, we have a question that will ferret that out. So I always tell my clients, tell me what you're thinking. Tell me what you're trying to do. Help me help you. So you got to be upfront with your lawyer so your lawyer can help you, because you get such a wonderful benefit from bankruptcy. Like you just said about, wow, that sounds like magic. Like
it sounds like magic.
IRS debt. It is very powerful. But you also have to be honest and you have to disclose, because there is bankruptcy fraud. It's a crime. And the FBI investigates bankruptcy crimes. You can go to federal prison. So you have got to be honest with your lawyer, because you may be thinking, oh, I'm just going to do this and it'll be fine. And if you had told your lawyer could have helped you figure out how do we need to handle this so that you don't have the FBI sniffing at you.
Absolutely. And I want to do a little sidebar about disclosure to your attorneys. Your attorneys are there to help you. And I can't say this enough to my clients. Yes. They think, I don't necessarily tell them no shame, no judgment. Maybe I should so that they can understand that I'm really not judging them. But when you're asking questions about your financial ability, like I'm talking from the business law standpoint, when we're talking about financial ability, your ability to secure a loan for your startup, for example, who else is going to be on your company records, those types of things that I've asked clients, and they seem to, for some reason, they have an idea in their mind what they want to do, but they don't necessarily disclose. Attorneys are there to help you. I know there's a lot of attorney jokes out there. We get a bad rap, but if you're engaging with an attorney is there to help you. So your best bet is to be completely honest with them, full disclosure, because then during that consultation, we as attorneys will be able to tell you, you can do this, you can't do that, don't ever say that again. Those types of advice that we can give you, but full disclosure is completely necessary because, in all fairness, you're coming to us because you don't know the law and we're trying to help you. And I hate to say it that way, but sometimes it upsets me when clients think a certain way. They don't tell me what it is that they're trying to accomplish. I do something for them, and then it turns out to bite them in the butt because they're not telling us exactly what it is that their intention was. And I can't advise you if you don't tell me what it is that you're trying to do. So if you think that you're going to go to a bankruptcy attorney and, like Theda said, you gave that $10,000 away to your brother, but you decide that you're going to be smart and you're going to try to not tell your bankruptcy attorney, and then you get into, say that again, Theda, it's a criminal matter at that point. Do not expect Theda to help you at that point because you should have disclosed to her. So I definitely have to do that sidebar on disclosure, because even the questions that clients come to me and ask me about bankruptcy, and I tell them that I'm not a bankruptcy attorney, and they throw out scenarios. I'm sure you get this a lot, Theda. Scenarios. What if I do this? What if I put the car in my wife's name? What if I decide to do that? It's all these scenarios that you throw out that you think you're helping yourself, but you won't know for sure until you fully disclose to your attorney and get the legal consult that you need. Mm-hmm. My personal sidebar on that, because at that point, if you're in litigation, you're being investigated, that attorney that you did not disclose to can't help you.
Right.
You're beyond that point already. Yeah. So sidebar aside. So the other question I usually get is, now you file for a bankruptcy. How long does that affect your credit? And will I ever be able to buy a house again or get a car again or a student loan or a business loan or a small business loan? How does it affect your credit, and how can you recover from any effects that the bankruptcy may have on your credit?
So depending on where you are when your bankruptcy case is filed, bankruptcy may improve your credit score. So you have to think about what is a credit score and why do we have it? We have a credit score so that people can loan you money. I mean, let's face it, banks are in business. That's how they make their money, loaning money to people and businesses. They want to do that. And a credit score helps them make a business decision on, should I do this or should I not? And if I do, what's my risk? And in loaning money, the risk means how much interest they're going to charge you. So can I get a car? Absolutely. The day after you file your bankruptcy, you can go get another car. I always say, this is America. We sell cars all day long. We want to sell people cars. We will find a way to finance it so that you can get a car. Now, if you have filed a bankruptcy and you're buying a car, you are not going to pay the same rate of interest as someone with a 720 credit score who has not filed a bankruptcy. So that's what it is. It's a matter of how much it's going to cost you to do that transaction. In terms of buying a home, it's usually 2 years after your discharge of a Chapter 7. If you are in the middle of a Chapter 13, you can buy another house. You typically have to have permission from the bankruptcy court in order to buy a house if you're in the middle of a Chapter 13. But the bankruptcy isn't going to stop you from doing what you want to do. Now, you can go get credit cards after you file a bankruptcy, a Chapter 7, and get your discharge. The credit card people are dying to have you back. And the reason why they're dying to have you back is because they know you cannot get another discharge in bankruptcy for 8 years. So they know that you sure, come on, we'll give you another credit card because we know that you're probably going to pay us. Because you can't go file another Chapter 7 bankruptcy.
For 8 years. I didn't know that.
Yeah, you can go file another Chapter 13, but a Chapter 13 is a repayment plan, so they might be getting some money in your Chapter 13.
Let's talk about the repayment. Obviously, you're going to have to restructure to be able to have your income pay all your debts. Now, are you paying the full debt, or are you paying cents on the dollar of that debt?
So there's a formula, and the formula is based on your income, your household size, and certain allowable expenses. And that's that test that I was referring to you. Mm-hmm. It's called the means test. I dropped the S and I just call it the mean test, because sometimes it can be have a very harsh result. Yeah. And it can say that you need to pay more than you can afford to pay. And then that's when you have to make some really tough decisions about your expenses. That's when I have to start talking to my clients about, well, you may not be able to go to Starbucks every day. You may not be able to take a family vacation. I know you're in Florida. I'm in Texas. I may have to tell people, no, you can't go to Disney because it's not a drive away. It's an airplane away. It's staying in the hotel. You may have to look at having a different kind of family vacation or a staycation. And I mean, those are hard decisions that you have to make. Those are hard conversations we have to have, but it's
necessary.
You're trying to do something different and get a benefit. So I'm here to help you make those tough decisions.
Before we get into that question, we have another question from a listener. Before we get into that question, Lisa, I think it's very important. You said something about, disclosure and some part of the process of the bankruptcy. I think it's important for our listeners to understand that the bankruptcy process doesn't mean that you necessarily just file and it's granted. There is a process where you have to talk to the trustees, correct? Because I think that that's the part that a lot of my clients, when I sort of go through a little bit of what I know, they're surprised that they have to justify what they write in their disclosure forms. So if you can take us through, of course, not in detail, but just take us through what a bankruptcy process will look like so that our listeners and those who are going to be viewing this on YouTube can see that it's not just a matter of submitting paperwork and then the magic happens, but that you do have to have some sort of, I don't want to say adversarial, but you do have an opposing party in certain cases.
So it is, you have what's called a meeting of creditors. Now, that's a little bit of a misnomer because when people hear that, they kind of think of like all their creditors coming after them at this meeting. Most creditors do not attend the meeting of creditors. And right now, those meetings are held telephonically. So you can sit back, relax in your jammies, and get on the phone. And when your case is called, the first thing is that you are sworn. You are under oath when you're giving testimony. But the questions are pretty, I like to be sure my clients are really prepared for that meeting. And I tell them the hardest question I'm going to ask you, and the attorney is primarily the one asking the question, is the hardest question is state your name. Because I'm going to help walk you through. So okay. Rishma, if you were my client and you came to me and you said, I'm having to file bankruptcy because I had this great boutique and COVID hit and I lost all my customers. And I personally guaranteed the lease for this business. I have 5 years remaining on the lease. I owe the landlord $1 million remaining on that lease. So I'm going to have to file a bankruptcy. And even if you had a mortgage of $400,000 on your house and you had gone out and you'd gotten a job and you were making money, but I can't pay the landlord $1 million. My income is just not sufficient to do that. We can file a Chapter 7 bankruptcy for you. Your debts would be primarily business debt because the landlord is your big creditor. At your creditors meeting, I would say, state your name. That's the hardest thing you're going to say. And then I would say, so, Miss Eckert, you had a boutique, is that right? And your answer would be, yes.
Yes.
And your boutique had no business. You had to shut your doors with COVID, is that right? And you would say,
yes.
And you have 5 years remaining on your lease and you owe the landlord $1 million, is that right?
Yes.
So that's how I like to run my creditors meetings so that my clients don't, because it's a little, even though it's on the phone and you may be at home in your jammies sitting there with your dog and so you're kind of relaxed, it's still, you're under oath. And
right.
And so
can they object? Is there a point where a creditor can object to your filing bankruptcy?
Yes, a creditor can object to their discharge of debt. That is very rare that happens, but it can happen. Usually it's because someone has committed fraud.
Gotcha.
Or we talked about disclosure before. I'm big on not only do you have to tell me, but I want to see the statements. Mm-hmm. If you decide that you're going to go to Neiman Marcus and go shopping on your Neiman Marcus credit card, and then you want to file a bankruptcy and you don't produce your Neiman Marcus statement to me so that I can see that you bought 3 Louis Vuitton handbags because you really wanted to gift them to your sisters and you knew you were going to file bankruptcy and you weren't going to pay your Neiman Marcus credit card, you're probably going to get, or your lawyer is probably going to get an email from the lawyer representing Neiman Marcus and said,
that's right.
You know that your client bought 3 Louis Vuitton handbags 2 weeks before they filed bankruptcy? Uh-oh. And then I'm sending an email to my client saying, those Louis Vuitton handbags you bought, you're actually going to have to pay for them. You're going to get a payment plan, but They could sue you. They don't want to sue you. They don't want to go through the expense of suing you, but they want you to sign a document saying that you promised to pay, just like you never filed a bankruptcy.
Because of the attempted fraud.
Right.
Specifically because of the attempted fraud. Okay,
Yeah,
Lisa,
fraud.
we have 2 questions from listeners. If you want to start with the second question.
Oh, yes. In business or personal, do I have to alert my creditors before filing for bankruptcy, or if at all, at which point do I do that?
You do not have to alert your creditors that you are filing a bankruptcy, because all of your creditors are listed in the paperwork that's filed with the bankruptcy court. And there's a noticing center from the bankruptcy court, and they send your creditors notice of your bankruptcy filing.
Okay. There's another one. It says, if someone filed bankruptcy and they have gone to court and was granted their respective chapter, if they should win the lottery after the final process, what happens to that case?
Ah, that's a good question. So, within 180 days from the date of the filing of your bankruptcy, if you become entitled to any sort of windfall, like a lottery, you do have to report that to the trustee. I tell my clients, let me know. And a lot of times how this happens is someone dies and they become entitled to an inheritance. Mm-hmm. Entitled, not received. That's a big distinction. So let's say your grandmother died and you had no idea that your grandmother had you in a will and was leaving you $30,000. But it's going to be tied up in probate for a while. So you file your bankruptcy. A month later, your grandmother dies. You're going to get $30,000. You haven't received it yet, but you are entitled to receive it. That's when you notify your attorney, who then notifies the trustee. And then depending on where you live, what exemptions are available, some or all of that money may be yours to keep. You just have to disclose. You've got to let your attorney know so your attorney can notify the trustee. And then we can figure out, what do we do with this $30,000?
Okay.
Great.
As far as like filing bankruptcy, how far behind do you have to get before you said, you know what, it's time to sit down with a bankruptcy attorney? Like 1 month, 3 months, 6 months or so?
Okay, there's no formula for that. But I always say you kind of know, like, I'm not able to pay my minimums on my credit cards and eat. I'm using my credit cards to pay my electric bill, to pay my groceries because I'm having a cash flow issue. That's maybe a time that you think, I probably should at least talk to a bankruptcy lawyer and see, is there
options
I need to think about? Yeah.
Yeah.
Okay. And I will tell you, most bankruptcy lawyers are really nice. I know people are like, I don't want to go talk to a lawyer. Most of us are really, really nice people. It's not that scary.
Yeah.
Most lawyers are nice. We just get a bad rap for some reason.
Yeah.
That's true.
So my other question is, you brought up a very good point about the with the full disclosure and the things that happen afterwards. Can you file for bankruptcy if you've been served with a lawsuit? For example, the credit card company sues you because you owe, I don't know, $50,000, or you get sued on a foreclosure matter, right? So you can't pay your mortgage and they've initiated a foreclosure. Can you file for bankruptcy after being served?
Absolutely. Yep. You can actually file even after the lawsuit is concluded and there's a judgment against you. You can file at that point. Maybe they've recorded the judgment against your homestead. You can remove that through the bankruptcy process. It's usually people file, I always say people file when it's too late. And by that, I don't mean it's really too late, but they have expended time and effort and emotion worrying about debt when they could have filed that bankruptcy and not have expended all of that time and emotion. They may be liquidating 401ks. I mean, that's what breaks my heart when I see people who come in and they've liquidated 401ks to pay debt And then
because they're trying to keep up. Yeah.
Right. And it breaks my heart because that's their retirement and that's long-term money. So it's there making money for you. You liquidate it. You've got a tax problem that you may have created and you still owe debt because it wasn't sufficient to pay all of your debt.
I want to ask some more questions about business bankruptcy because, you know, it's Minding Your Business and we are doing a business program. I think she answered that question already, Lisa. I'm sorry. Like, how long does the bankruptcy stay? Oh, no, she hasn't. How long does the bankruptcy stay on your credit report? Was another question from our listener. And then I'll get into my question about the business bankruptcy.
Sure. It's 10 years from the date of your discharge. In a Chapter 7, your discharge comes about 90 to 100 days after your case is filed. In a Chapter 13, it's 3 years or 5 years before you receive your discharge, depending on what plan payment you're required to propose.
Okay.
So it's going to be on your credit, but it's not the end of the world.
Is it also recorded when you've satisfied all the repayments? Then is it recorded somewhere where it can help your credit report?
You get a discharge order. So yes.
Okay. And that would be, I guess, whoever's pulling your credit to be able to issue you any sort of loans will see that it's already been satisfied.
Yes. Yep.
So that's a major plus.
Yep.
Yeah.
For you.
Discharge is important. It's a good thing.
So for the business bankruptcies, and again, because I get a lot of the questions about the business bankruptcy, let me see, how should I ask this question? Is there a way where the business bankruptcy affects you personally, your personal assets?
So if you have a business entity that is a true standalone entity, and you have not been required to personally guarantee the debts of the business, and so every debt of the business is not tied to you personally, then no, that will not affect you. For most small business owners, that is not the case. Most small business owners are required to personally guarantee. When you're like your boutique that we gave you.
Yeah.
You had to sign the lease, not just in your capacity as the owner of the boutique, but also in your personal capacity. So
that's correct. And even SBA loans, small business loans, absolutely. Many of them require you as the owner to personally guarantee. Yeah. So, which leads me to my other question that Lisa and I sort of contemplated the last time we had our show. How is it that we hear about a lot of these really supposedly wealthy business people filing multiple bankruptcies all the time? And I can name someone that we're thinking about right now, but I refuse to say his name. That they filed, you'll see it, multiple bankruptcies, 4, 5, 6, 7 bankruptcies for huge businesses, and they're still wealthy personally. How does that happen?
So how that happens is just like we just talked about. They are not required to give any personal guarantees. They have this standalone business. It's, Page Inc. And Theda Page didn't personally guarantee any debt for Page Inc., which is a rarity.
It's a rarity because usually for the types of businesses that I'm thinking is that you do have to have collateralized security agreements. Yeah. So, I mean, it's sort of unheard of every time I hear about certain wealthy people with the bankruptcies and all the people that have all the creditors who now can't be paid for whatever services that they've offered for that business. It just seems so unfair in a way.
So even though I represent debtors and that's where my heart is, I do feel for the creditors in that instance because those lending institutions didn't require any type of personal guarantee. So that's on the lending institution and they have to answer to their board of directors. And that's why you hear about some people where they say, well, nobody would lend to them anymore.
Yeah, they somehow find other lenders that don't require the collateralized security agreement or don't require a personal guarantee, like you're saying. Yeah. We do have another question, Lisa. Can you please read it?
Yes. Before I read the next question, I do want to remind our listeners that this is not specific legal advice, guys. This is general information. And for specific legal advice, please make sure that you consult with a licensed attorney. The next question says, is there anything that can be done legally to erase a bankruptcy charge from my credit profile before the allotted 10 years?
That is a question that I cannot answer because I hear that people do that, but I'm not sure how they're doing that because a credit report has accurate information. And if, in fact, you have filed a bankruptcy, that's a fact. So,
how are they doing that?
I do not know, and I don't want to know.
We should ask our listener to let us know how they're doing that so that we at least know what's going out there. More into business bankruptcy. So you're bankrupt, your business is bankrupt, you're not a personal guarantor, you don't have any other entanglements with your business versus your personal. Can you just go ahead and start a new business and open that up? Yeah. And, seek funding, seek vendors. Again, is there a database of businesses, or is there a database where a lender or someone can go and a funding person, a hedge fund, whatever, can go and see that you have had these multiple bankruptcies in business and maybe might not want to lend to you?
So what they're probably going to do when they're thinking about lending to you is they're going to have some questions, and their questions are going to ask those kinds of questions. It may be, have you ever filed a bankruptcy? It may be, have you been a shareholder in a business that has filed a bankruptcy? So that's more on the lender's side of it, the decision-making process that they're going through.
Another question I have is, who can initiate the bankruptcy in a business? Does it have to be consent of all the owners? Can it be one owner? Can it be a board, a manager? Who has
authority? Ownership.
Majority. Okay.
You may have heard about the NRA and their bankruptcy filing. And they filed in Texas. They're based in New York.
Yeah.
And they filed their bankruptcy actually right here in North Texas, in Dallas. And the bankruptcy judge dismissed their case about a month ago.
Okay.
One of the things that, one of the reasons why, first of all, their chief financial officer testified that they were financially healthy and growing. So they did not file bankruptcy for a financial reason. That's not the typical case for a bankruptcy filing. But what they were trying to do is get away from litigation, in regulatory litigation in the state of New York.
That was going to be one of my litigation type questions, is that, you're filing bankruptcy when you, as a, regular business owner or an individual, you get served with a lawsuit and you file. Now, I can imagine that companies, like you're saying, or organizations are trying to do the same thing. What sort of criteria do they look at to come to a conclusion like that? That you're thriving, you're growing, this is not a real bankruptcy for the purposes of filing.
Right. So the state of New York was one of the parties that filed that motion to dismiss the NRA bankruptcy. So one of the things that they kind of got busted on was their filing. They did not tell their general counsel. So their chief legal officer was not aware that they were filing a bankruptcy. I don't think they told.
Oh, how is that possible?
Yeah.
Wow.
Yeah, they were not transparent in disclosing that they were planning to file bankruptcy. It was basically Mr. LaPierre who made the decision. He did it in conjunction with outside legal counsel. But that's not a cool thing for a business to do, is to not disclose. Now, they don't have to tell every shareholder we're filing a bankruptcy, but usually, depending on the size of the business, it's a shareholder decision, it's a board meeting decision.
Absolutely. Shareholders meeting, yeah. For something like that, major financial decisions are held by, the shareholders have to approve it, the board has to approve it as well. My other question that I have, and I see some more questions coming in, Lisa, but I want to ask this one before I forget again. So in terms of disclosure, what if you have foreign assets and foreign bank accounts or offshore accounts?
That'd be disclosed. Yeah.
Everywhere within the world, right?
Right.
So you can't say, well, I live in the U.S. I'm just going to tell you all my U.S. Assets because, Belize, I'm from Belize. Lisa's from Jamaica. We're not going to tell you what we have in our other countries because we don't live there. Yeah. That's not how you do it, right?
Nope. Doesn't work like that. Got to disclose. And I mean, it may be that asset isn't worth a whole lot. But yeah, you have to disclose it. It's got to be listed in those papers that get filed with the court. If it's a Chapter 7 trustee, the trustee might be the owner of that property now that you have filed a bankruptcy. And some people, timeshares are one of those things. Some people they own it, but they don't want it.
Yeah, that's such a good point because you get it like 2 or 3 weeks out of the year. I don't really see that as an asset, but you're right. It's a part ownership.
Yeah, it is an asset.
Yeah.
It's probably the Chapter 7 trustee's least favorite asset because nobody wants it.
No one wants it. You can't even sell your timeshare these days to anyone else. You can't even get out of those contracts and you can't sell them. You're pretty much stuck. I've turned away some timeshare cases because I'm like, I'm not finding this. I'm sorry. So yes, disclose all your assets. For our international listeners, everywhere in the world, you have to be able to disclose all your assets. I see that there's another question that came in, Lisa.
Yes. So if I co-sign a debt with another person, how does that person filing a Chapter 13 bankruptcy affects me?
Okay. So that happens a lot. Because people who are in financial difficulties, that usually their financial difficulties didn't start a couple weeks before they filed bankruptcy. So they may not have been able to buy a car. So they needed a co-signer to get a car. So the co-signer gets listed as what we call a co-debtor on their bankruptcy. So I recommend, if you are that person who is the co-signer and the primary has filed a Chapter 13 bankruptcy, that you write a letter or note of explanation in your credit file. I did not file bankruptcy. I co-signed on a car loan for my son. My son ended up filing bankruptcy. If it's truly a car loan and the son wants to keep the car, they're going to keep making the payments. And so it should be a non-event, but you do want that note of explanation so that your credit file isn't flagged as a bankruptcy. If that person defaults on that loan, the lender's going to expect payment from you. That's why they wanted a co-signer.
Correct. So we talked about discharging certain debt, and you talked about exceptions. What are the exceptions to what you cannot discharge in a bankruptcy?
Taxes that are recent taxes. So there are all kinds of rules about being able to discharge taxes, but if you just think about, these are my 2019 taxes, they're not going to be discharged.
Okay.
If you have
back taxes
that are more than 3 years old, you timely filed that tax return, you just didn't pay the tax, but you got your tax return filed on time, that tax is, and the IRS didn't come back and challenge or say you need to amend your return, you probably can discharge that in a bankruptcy. If you are looking at trying to discharge taxes in bankruptcy, That's a very specific issue that you're going to want to talk to the bankruptcy lawyer about. You're going to bring out all your documents, go over all that with the bankruptcy lawyer.
Student loans. Another question I get all the time, student loans.
Yes. Those are probably going to follow you to your grave.
Wow. Especially law school ones.
That's very, very disappointing.
Yes, that's the...
So I tell people, write your congressperson. But yes, but here's the flip side of that. Let's say you have a lot of student loan debt and you have a lot of credit card debt. You can get rid of your credit card debt, and by getting rid of your credit card debt, you may be able to afford to pay your student loan debt.
That's a good point. That's a very good point. Eliminating certain debt can help you consolidate for the things that you actually have to pay for. Right. So for the benefit of our listeners, let's do a quick checklist. Credit card debt, dischargeable, right?
As long as you weren't buying those Louis Vuitton handbags 2 weeks before filing.
Exactly. As long as we're not maxing out for the purposes of, fraud, credit card debt for the most part. Medical, I heard you say medical expenses as well.
Medical debt.
What else?
Payday loans.
Payday loans, really?
Debt consolidation loans, any type of, unsecured or if you go and get a title loan on your paid for car, they've got collateral. But just think about anything where there's no collateral. Okay.
So unsecured loans, car we talked about, the house we talked about as well, student loans we talked about, unfortunately. Yeah. I'm just trying to go through a checklist of all the different types of expenses someone may have.
Rishma,
yes.
Before you continue, I just want to ask Theda about the student loan forgiveness. I don't know if you can speak about that. It's in the works that I've heard about so much. Student loan forgiveness. What does that mean, and how can someone who has student loans benefit from something like that? How do they go about that?
So there are income-based repayment plans for student loans, and that has a forgiveness component to it. I am not a student loan expert. There are lawyers they're the student loan lawyers. So they can talk more about, there are lots of programs available.
Right.
But you cannot file a bankruptcy to get your student loan forgiven, as in discharged in bankruptcy.
And there's go ahead. Sorry.
There are some very specific circumstances in which you can do that. You file a lawsuit through your bankruptcy against the student loan lender. But the classic case that we talk about is the dentist who was in a car accident, could no longer practice dentistry, obviously had a lot of loans from going to dental school, could work, but could not work as a dentist. So didn't make the same kind of money that he would have made by being a dentist. He could not get his dental school student loans forgiven.
Got you. And there's also a distinction to be made between government student loans and private student loans. Because I think when you're talking about the student loan forgiveness, Lisa, you're talking about programs that are out there where if you work in the public service, after a certain period of time, you may be able to get some of the student loan forgiven. I think you're talking about programs like that. But if you're in the private student loan business, that's probably even tougher to get out of or to discharge or to even argue with, right? I'm thinking about people like me who have private student loans for law school. Like you said, it's going to follow me for the rest of my life, probably.
That's one of the benefits of being old, because law school didn't used to be that expensive when I went to law school.
Wow. Yeah. It's definitely probably my biggest expense. But on the flip side of it, had I known now, would I have done it again? Absolutely, because I love what I do. So there's always that flip side. You take the good with the bad in life. That's just how it is.
I think with the first year in law school was $900.
Oh God.
It's definitely not that now, especially if you go to a private law school like I did. It's definitely not $900. Wow.
That was almost 40 years ago.
True, very true. With our last few minutes, Theda, I wanna give you an opportunity to give any suggestions or recommendations before I do my wrap up for the show.
Sure. So, I always say, go talk to a lawyer. Information is power. So, you might ask Rishma. Reach out to a lawyer you already have a relationship with and ask them, can you give me a referral for a bankruptcy lawyer? I just want to talk through and see, because the lawyer might tell you, you know what, you're good. These are some things to think about. Just because you go talk to a bankruptcy lawyer doesn't mean that, yep, you're going to be filing bankruptcy. You may not. You may think that your situation is one that requires a bankruptcy, and it doesn't. But you should at least go talk to a lawyer. If you have been sued, you definitely want to go talk to a lawyer. Whether it's a litigation lawyer who's going to handle that, defend that lawsuit for you, or that lawyer may tell you you probably should go talk to a bankruptcy lawyer. Because one thing's for sure, if you've been sued by one credit card, the rest are coming too. So,
absolutely. Theda, thank you so much for being a guest on our show. And if you would like to get in contact with Theda, please go ahead and give us all your contact information.
Sure. My website is pagelawfirm.com, and that's PAGE, like page in a book, pagelawfirm.com. And our phone number is 214-618-2101, or you can shoot me an email, theda@pagelawfirm.com. And I'm not a Greek letter, so that Theda is THEDA.
Good point. Very good point for our listeners who can't see this.
Yeah. And if Instagram at Theda Page.
Theda Page. And if ever in doubt, just go ahead and send an email to info@mybshow.com, and I would most certainly send you to all of Theda's information. I'll connect you guys on email, and then you can go from there. So thank you so much for doing this show. We have been getting a lot of bankruptcy questions, and we needed that resource. We wanted to be able to provide that information to our listeners, and you stepped up, and I absolutely am grateful for you doing that. And for our listeners out there, for my wrap up, I want to say, kind of jump on the bandwagon that Theda is saying, do the consult, because do not believe everything that you read online. My wrap up was going to be about, in our age of technology, you Google everything and you get all these different opinions on what is going to be beneficial for you, if you're eligible, if you're not, what's discharge, what's not, what happens to your credit report. It's a lot of information. Some of it might actually be in conflict with each other. So your best bet is absolutely do the consult and find out what's best for you. If you're a business owner and you are going through hard times, and like Theda said, the pandemic hit us and we didn't really know what to do or how to respond, don't see the option of filing for bankruptcy as something that, is a failure for your business. I want you to see it as an opportunity to get better and put in the work, do the research, look at your resources that you have. Don't always believe what you read online. And remember that you have to put in the work, because success comes when you're minding your business.
The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.